Hello, Mike McKinley here with Elder Care Law of Kentucky. I'm making this video specifically as a message and appeal, reaching out to other attorneys who are not elder law attorneys, but do in fact serve people who are over the age of 65, say. Um, Let me say this. If you're an attorney and you're going to do estate planning documents for someone who is elderly, over the age of 65, be very careful. Be very careful because I would say 85 to 95% of the power of attorney documents and the wills that I come across by clients who meet with me who have already had work done previously by a different attorney, they're not adequate, they're not proper, and some of these documents border on malpractice, in my opinion. And I'm going to get into why. So here are the main issues. The most important issue is the power of attorneys that non-elder law attorneys are drafting. Now, the traditional power of attorney document was a 2 or 3 page boilerplate, probably the same document the guy who taught you how to do it used. Basically, very generic, just broad powers. If I can do it, you can do it. Okay? Those don't actually work for elder law planning. So if I have a client comes to me who's just entered a nursing home and they're asking me, Mike, can you please help me save any of their money from the nursing home, from the Medicaid spend down? The first question I have to ask is, well, do you have a power of attorney for your mother or your father, whoever's in the nursing home? If they say yes, I still have to ask, well, let me see it to see if it's going to be adequate. Okay? Unfortunately, they're often not adequate, okay? But here's what makes them inadequate. I've got to have a specific power listed in the power of attorney document, giving the attorney, in fact, the ability to make gifts of unlimited amounts. The gifting amount cannot be limited to the IRS gift tax exemption, whatever the annual gift tax exemption is. And almost all of them are from attorneys who are not elder law attorneys. I understand that was traditionally the way you did it. It was more for estate tax reasons than it was for any other reason. And my answer to you, if you're concerned about gifting, is this. First, if you can't trust your attorney, in fact, not to give all the money to themselves or to squander it or to do something else, they don't need to be the attorney, in fact, in the first place. Okay? The other thing to say is if I'm creating an irrevocable trust or I'm trying to do a crisis Medicaid plan to protect a portion or maybe all of the money for the elderly person who's in a nursing home, I have to be able to give their property, make a gift to a trust or to a child who has a disability or whatever the other loophole I'm using to protect that money. I have to be able to make gifts. If you're limiting the gift to the annual exclusion, I can't deed a house and do a trust because most houses are worth more than the IRS annual exemption. So that's the biggest issue. That's the one I run into the most. Another is the ability to transfer property has to be specifically listed. That's usually in there, but unless the gifting is also listed, I can't give it to a trust. I could sell it to a third party, but that does nothing to help me. I need to be able to transfer a piece of real estate pursuant to a power of attorney document into a trust, which means I'm making a large gift, which means that if your power of attorney is limiting the gifting ability, it's inadequate. It doesn't help me. We'll get to the consequences of that in a moment because they are severe. The next thing I need the ability to create trust, inter vivos trusts. Technically, that's supposed to be listed as a specific power in these power of attorney documents. I also need the ability to apply for governmental benefits that they might be entitled to. That also should be listed as a specific power, not just a general, if I can do it, he can do it power. Now, if I had my preference, I would have a limiting power in that, or I should say an exclusion in that power of attorney, specifically not granting the right to enter into binding arbitration agreements. The Supreme Court has said that a general power of attorney does grant the ability for the attorney in fact to forfeit, to forego, to waive their constitutional, the principal's constitutional right to a trial by jury. Well, if you're drafting these general powers, you're giving them that power. So when little Johnny signs his dad into the nursing home and he signs a stack of documents that thick, one of those documents just happens to be a binding arbitration agreement, and then later the nursing home kills dad due to some type of neglect or abuse or what have you, or some type of negligence. Little Johnny can't sue the nursing home, all because you drafted this power of attorney, giving him the full general powers, and he just didn't know any better when he signed all the documents. Most of my clients don't know what a binding arbitration agreement is. So I always put a provision in my POAs specifically excluding that power. You do not have the power to enter me into a binding arbitration agreement. And I tend to hide it in the document just with all the other wording so that it doesn't stand out, especially to the facility, so that they won't reject it out of hand simply because it's in there. And so that those are the main issues. Now let's talk about the consequences. Client comes to me, I've got a POA. Great. Mom has dementia. She's totally disabled mentally. She can't sign anything. Okay, but you have a POA. Yes, I do. Let's read it. I read through it, and of course, gifting is limited. It says nothing about the ability to make inter vivos trusts or QITs or anything else. What does that mean? That means that the POA that the attorney drafted isn't worth the paper it's written on. It's worth substantially less than the paper it's written on, because now we have to go through a guardianship court to get permission to protect this person's assets. Permission to do planning that they would otherwise have every right to do, but for their mental incapacity. So now I've got to wait 2 or 3 months for the guardianship court to go through, to run its course, get all the the tri-party reports submitted and all the hassle, all everything. And now we've got a judge involved and a county attorney involved that my client may or may not like or may not have voted for. It's a lot of hassle, and you're adding a minimum of $2,500, $3,000 just in legal fees to my client's expenses, not to mention the 3 to 6 months that it takes for us to get all of the planning done through the guardianship court. Okay, that's 3 to 6 months of nursing home payments that they might not otherwise have to make. $30,000, $40,000, depending on which nursing home you're going to. Okay, that is an expensive error, all because the attorney who drafted the POA didn't give us gifting language specifically in the document, or they limited the gifting to the annual exclusion. If you're going to help people, you need to help them. If you're doing estate planning for someone who's 65 and older, and you're creating these POAs that are effectively worthless, you're not helping them, you're hurting them. My advice is reach out to me. I'm happy to give any attorney a free template saying, here's how you do this. I would much rather you have this template and not screw these power of attorneys up for your clients. Free of charge. I'm happy to have this discussion with you. My partner, Jamie Hargrove, he's primarily out of Louisville. He and I had this discussion face to face, and I showed him all these things. And another conversation we had was about testamentary language in wills and in trusts. If you don't have special needs trust language in those documents, what are you doing? Why would you not have special needs trust language in every testamentary document that you create? What does that mean? If by some chance my son or my daughter is disabled when I die, the money doesn't go directly to them, thereby screwing up their SSI or their Medicaid or whatever other benefit that they rely on, that they are dependent upon. Okay? It goes into a special needs trust. That provision only gets triggered if one of the beneficiaries is disabled. I have clients in their 90s who have children in their 70s. There's a reasonable chance that when dad dies, son may already be in a nursing home. And dad dies leaving son all the money. Who gets the money? The nursing home gets the money. You think that's what your clients want? No, they don't. I've never had a client say they wanted to give all their money to a nursing home when they died. No more than they want to give it back to the state in taxes. Those people don't exist. So if you're not putting special needs trust language in your wills and these simple wills that you're having, I know attorneys, they'll do a will for $150. That $150 could cost the client's family hundreds of thousands of dollars on the back end. So you're not helping your clients if you're doing this. But back to Jamie, he and I had this conversation, and he says, "Oh my God, Mike, I'm committing malpractice every time I draft a document for someone over the age of 65. I said, "Exactly. That's exactly what's going on." So therefore, he's like, "Well, you just become my partner and that'll solve all the problems." We immediately went in and changed all of his documents. 100% of them now have special needs trust language in them. You do it one time, you copy it to all of your documents, it's done. There's no reason not to do it, okay? There's no good reason why, if you have a disabled beneficiary, that you don't want to leave that property to them in a special needs trust as opposed to just giving it all to them outright. And there's ways to unwind them for various reasons. They become, they're no longer disabled, or for some reason it just doesn't make sense for them to have it in a special needs trust. You can undo it, but unless you put that language in your testamentary document in the first place, courts are not going to come in and change a will posthumously to create special needs trusts. They just won't do it. So you may be doing more harm than good with these documents. Now, personally, I put them in all my documents regardless of the client's age, but most especially I do it for the elderly. They're the ones who are most likely to have someone who's close to being disabled or already disabled. So again, I'm happy to have a conversation. If you disagree with anything I've said, please reach out to me. I want to have this discussion. I'm happy to be proven wrong. I enjoy learning. So if you think I've said something that's not right, that you disagree with, by all means, reach out to me. 859-298-2150. Check out my website, eldercarelegacy.com. If you want to partner with me to do co-counsel, for every client, I've got attorneys around the state. Every client above the age of 65 that I get co-counseled, I get brought in. We share the fee. I do all the work. I do all the drafting. I create all of the documents. And all they've got to do is call me and we get this done. Now, it's being done properly. There's no question that your clients are receiving the best service and attention and documents that you can possibly provide to them. And it's a great solution all the way around. But if all you wanted just to talk about the POA issue, that's the biggest issue I run into. And the most costly, because it affects everyone. I shouldn't say everyone. Everyone who eventually develops dementia, which is almost everyone if you live long enough, the POA issue affects. Now, not everybody has a disabled child when they pass away. That's actually a small percentage of people. But when they do, when the issue does arise, it can be catastrophically expensive for the beneficiary and very wasteful as far as where the money goes once the client passes away. Reach out to me. I'm happy to have this conversation with you. Again, anybody can watch this video, but I'm really talking to you attorneys out there who are doing this type of planning. I'm happy to help, and I hope nobody takes offense to me saying these things, because I'm just trying to avoid problems that I run into every week at least. I run into an ineffective power of attorney that was produced by an otherwise competent attorney, and there's just no reason for it. Hopefully we can solve these problems before they become problems. So thank you for your attention and time, and have a great day.